Abortion. It's been a hot topic as long as I can remember. Probably as long as most of us can remember. And even recently, the controversy surrounding abortion hasn't subsided. In fact, Ohio has recently called out to create and pass what they called the heartbeat bill, which essentially would have prevented any abortion of a fetus that is determined to have a heartbeat. Now, before we get into exactly the Ohio bill and the workings around that bill, it's important that we discuss some of the history that led up to the present day laws pertaining to abortion. And really, this all started in 1965 with the case of Griswold v. Connecticut. And in that case, the court struck down a state prohibition against the prescription sale or use of contraceptives, even against married couples. And in Griswold, the court held that there's this constitutional guarantee to a right to privacy when individuals make decisions about intimate personal matters such as childbearing. Now, in 1971, in United States v. Vuitch, this was the first case regarding abortion to reach the Supreme Court. And in this case, a doctor challenged the constitutionality of the District of Columbia's law permitting abortion only to preserve a woman's life or health. And the court rejected the claim that the statute was unconstitutionally vague and concluded that health should be understood to include considerations of psychological as well as physical well-being. And the court also held that the burden of proof should be on the prosecutor who brought the charges and not on the doctor. Now, the next year in 1972, in Eisenstadt v. Baird, the Supreme Court struck down this Massachusetts law which limited the distribution of contraceptives to married couples whose physicians had prescribed them. And this decision established the right of unmarried individuals to obtain contraceptives. Now you find out you're pregnant. What do? You decide, for whatever personal reasons, that you cannot have a baby. And this could be health reasons or otherwise. Now, fast forward 1 year later, after Eisenstadt v. Baird in 1972, and that's when the pinnacle case in 1973 of Roe v. Wade was decided. And in Roe v. Wade, this case challenged this Texas law which prohibited all but life-saving abortions. And the Supreme Court invalidated the law on the ground that the constitutional right to privacy encompasses a woman's decision whether or not to terminate her pregnancy. And it characterized this right as fundamental to a woman's life and future. Now, the court held that the state could not interfere with the abortion decision unless it had this compelling reason for regulation and a compelling interest in protecting the potential life of the fetus could be asserted only once it became viable, which was usually at the beginning of the last trimester of pregnancy. And even then, a woman had to have access to an abortion if it were necessary to preserve her life or health. Now, 6 years later, in the case of Bellotti v. Baird, the plaintiffs were challenging this Massachusetts law that required women under 18 to obtain parental or judicial consent prior to having this abortion. And the court found the statute unconstitutional because as it was interpreted by the state's highest court, it gave either the parent or a judge absolute veto power over a minor's abortion decision, no matter how mature the minor was, even though it could also be in the minor's best interest to have the abortion. So in Baird, it established that all minors have to have the opportunity to approach a court for authorization to have an abortion without first seeking the consent of their parents, and that those alternative proceedings must be confidential and expeditious. Now, in 1983, in City of Akron v. Akron Center for Reproductive Health, the Supreme Court struck down all of the challenged provisions of an Akron, Ohio ordinance restricting abortion. Among other holdings, the court ruled that the city could not require minors under 15 to obtain parental or judicial consent for an abortion, require physicians to give information designed to dissuade them from abortions, impose a 24-hour waiting period after the signing of the consent form, or require that all second trimester abortions be performed in a hospital. Now, in 1992, and this is an important case, it was Planned Parenthood of Southeastern Pennsylvania v. Casey. And in Planned Parenthood, this case was a challenge to a set of onerous restrictions on abortion enacted in Pennsylvania. And in Casey, the court preserved the constitutional protection for the right to choose. However, the majority of the court actually overruled the trimester time frame that was the pinnacle of the Roe decision. And what the court actually did in Casey was they actually indicated that science had progressed much more than what was known at the time of Roe. And it has proven that a fetus could be considered viable at 22 or 23 weeks rather than at the 28 weeks that was previously understood by the court in Roe. So the plurality of the court in Casey redrew the line of increasing state interest at viability rather than that trimester framework because of the increasing medical accuracy about when viability takes place. So under this new viability framework, the plurality held that at the point of viability and subsequent to that point, the state could promote its interest in the potentiality of human life by regulating or possibly prescribing abortion, except where it's necessary in appropriate medical judgment for the preservation of the life or health of the mother. And what the plurality did in this case was they actually got rid of that strict scrutiny test that essentially said that in the third trimester you can't ban abortion whatsoever, and instead created what is now the present day test known as the undue burden test, which says that state regulations can survive so long as they don't place a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. Now, in 1997, in a case called Schneck v. Pro-Choice Network of Western New York, the Supreme Court upheld a fixed 15-foot buffer zone around clinic doorways, driveways, and parking lot entrances, and it struck down a floating 15-foot buffer zone around people or vehicles entering or leaving a clinic, essentially providing this safe space for people who were going in to get this abortion. Now, there's been many cases in between the cases that I've mentioned, as well as subsequent cases to the cases I have mentioned. But nonetheless, the same rings true today, that there's many on both sides of the argument, both pro-choice and pro-life. And what has recently happened with Donald Trump's election, it has fueled some more controversy surrounding the abortion issue. And with Donald Trump's election and his indication that he would appoint conservative Supreme Court justices, it spurred Ohio Republicans to pass what would effectively be the nation's strictest time-based abortion law. And Ohio lawmakers introduced this law known as the Heartbeat Bill. And this law would have banned abortions in that state from the moment the heartbeat of a fetus could be detected, which is usually about 6 weeks into a pregnancy. Now, what's the problem with that? The problem with banning abortion at a fetus's heartbeat would essentially preclude a number, probably the majority of people, from seeking abortions. Most people, most women, don't know that they're pregnant until they've missed their period. And even then, they might think that they're late. And after that, may wait a couple of weeks to see what happens. They may not even know that they're pregnant until after 6 weeks, until such a time that they find out, and then they may decide to get an abortion, make an appointment with the clinic, go in for the consultation, and issue the scheduling. By the time all of this is done, well, the 6-week time span has passed because the heartbeat is already present. So they're not going to be able to have that abortion. So the question begs, is this an undue burden under the current test that was promulgated in Casey? And I would venture to say that it is. However, with the recent death of Justice Scalia and President-elect Trump's promise to put a conservative justice in the court, this could have been the opportunity for the reversal of Roe v. Wade. Now, the bill was passed, and it went up to the Ohio Governor Kasich's desk, in which he actually vetoed this bill. And instead, in Ohio, the law now that was passed is this 20-week bill that says that no abortions can happen after 20 weeks unless it's to save a woman's life. However, recent news has indicated that Republicans in the House and Senate of Ohio are seeking to overturn Kasich's veto. And they would need a 3/5 vote to do that. And that would mean 60 of the 99 lawmakers in the Ohio House and 20 of the 33 in the Ohio Senate would be needed to override a veto of the bill. Now, the heartbeat bill won approval in the Senate by 21-10, but only 56-39 in the House. So there would need to be 4 more people who would need to be persuaded in the House. However, other sources indicate that 2 House members that weren't present for the initial vote would support an override, meaning that only 2 people would have to be persuaded to override the veto. And if that were to happen, what would essentially take place is abortion would essentially become illegal in Ohio, and it would create an opportunity for people seeking abortion to appeal this up to the U.S. Supreme Court, and for the U.S. Supreme Court, depending upon who is sitting at that time, to decide whether or not this is an undue burden, or if the undue burden test should be completely abandoned altogether and the holding of Casey and Roe v. Wade should be completely thrown away, and whether or not abortion will still be considered a fundamental right of due process and liberty under the United States Constitution. So it still remains to be seen what's going to take place. But I am quite sure that within the upcoming months to the next few years, we are going to see a lot of evolution in this area.